Recording in progress.
Hey everybody, this is Immigration Lawyers Toolbox. No, actually, hey everybody, hey fellow Toolboxers, this is John Khosravi. That's what happens when you try to do audio recording separately from video recording and going live for the first time in a long time and going and doing the top 10 episode, which we've got a lot of emails and people contacting us saying what happened to the top 10 things we've learned, podcasts we did. And so I said, hey, let's get back into it. It's a lot of fun talking about this stuff, talking about what I learned. It just was a difficult 2 quarters for me, just because of family responsibilities and firm responsibilities and the toolbox, all this kind of stuff. But sometimes you got to do what you got to do and get things done, even if it's on 6:30 a.m. On a Monday before 4th of July. So happy Independence Day, everybody. We're going to have an episode where we go over 10 things I learned. And I'm going to try to get back into doing this kind of episode because I think it's probably most valuable for practitioners and people in the field to learn about this stuff. So with that, let's get into it. We're going to have, well, before we get to the top 10, we do some housekeeping. The ILT conference happened about a week and a half ago. It was a lot of fun. I had the opportunity to meet with a lot of great colleagues and talk with them. So we're going to have a lot of colleagues coming on the show as guests and doing some special stuff. So if you're a member of the Circle.so group page, community page, which every immigration lawyer could join, there's no fee for that group. We're going to be posting a lot of content over there, especially like practice management and legal kind of stuff, seminars, CLE type information there. So just email me, info@immigrationlawyerstoolbox.com to just get your email in that group and you get notifications. So it's gonna be a lot of fun. The conference itself was like a blast. I kind of just go walk around outside and go into seminars itself. For me, it's just an excuse to see listeners and friends and all that kind of stuff. So it's a really good situation because the community aspect of immigration law and to be a better practitioner is so important. So I always recommend doing that. So along with that, I did create a group, like a peer mentorship group. It's a paid group. Email me for information about that. But it's for people that have solo practices who want to grow and take next level. We discuss and share information about taking things to that next level. So email me about that. By the way, the magazine, the new issue is out. It's been out for a little bit of time. Issue number 7 of the Immigration Lawyers Toolbox magazine. If you go to iltbox.com or immigrationlawyerstoolbox.com and /magazine, you can catch that over there. I want to thank one of the sponsors for the magazine, the sponsor for the show right now, DocaWise.com. You might have saw their post if you went to the conference, their booth that they had, but their name was everywhere. So it's the organization is going hard at it because they're really a top-notch organization. DocaWise.com is the place to go to get a test drive of the software. If you don't use it already, check it out, or just upgrade, get that annual plan to lock it in, especially because you get a better price if you do that. So it's DocaWise.com for your immigration practice management needs. On a side note, I'm redoing the marriage green card course. We add a lot of stuff to about K1 fiance visas, I-75 removal conditions. So if you have so much of firm and you don't want to do the training, well, we have video series and office hours that go with it for that training. If you're a person that's practicing other areas of law and thinking about tipping your toes in and diving into immigration law, that's the place to start. Marriage, immigration, consular processing, adjustment of status, learning inadmissibility, what it means, how to spot it, all that kind of stuff. And if you're listening, please leave a review wherever you're watching this, a 5-star review, so more people can learn about the product and the podcast. And as always, this isn't intended for individual legal advice. This is general kind of content. Talk with an immigration attorney about your case. All those kind of disclaimers that we have to give. I'm not your immigration lawyer. So let's get started into it. The first thing I wanted to talk about is a topic I don't handle, so I'm going to be brief as possible. I'll put that first get out of the way. But apparently, if you have an asylum case and you're filing the asylum case after you've already been received an NTA, notice to appear in immigration court, you're supposed to mail the filing to the Asylum Vetting Center, some sort of separate mailing location, not to what the typical USCIS-based location is, maybe on their website. So let's go to the Asylum Vetting Center. I read that, so I wanted to share that. Secondly, more in line with what we do, and actually have a case coming up like this, I read colleagues stating this and asked my associate, he had this situation pop up as well, which is where if you're doing a PERM case and the PERM is based on someone who's already a beneficiary applicant, is already in the United States on E2 status, not only later on when you file for adjustment of status, you have to file that extra paperwork. I think it's 589 or not, 589 is asylum, but it's some special paperwork to file if someone's got an E2 and they're going to go and adjust status. But with regard to the PERM audit, Department of Labor asks questions about the case thinking that the E2 status is triggering some issues with it, and if they're really an employee or not, or if they're like actually an owner of the company, which triggers some other issues. So be on the lookout that, when you're doing an E2 and then PERM, they might hassle you about it and ask questions that are irrelevant, maybe about ownership and how much control the foreign national has over the company because they have an E2. Apparently that is triggering some stuff. Third point, the Fifth Circuit has says that NIW denials can't be appealed to federal court. Apparently, the way they read the statute is that the NIWs, the national interest waivers, are discretionary in the Department of Attorney General, which really means DHS. So in this case, 2019 appellant filed the Form I-140 for a visa under 8 USC 1153b2 NIW, and the adjustment of status form. And appellant's I-140 asserted that he satisfied the requirements. USCIS declined to grant the I-140, denied request for reconsideration. Appellant sued the U.S. government, challenging the denials of I-140 and his motion for reopen reconsideration. Government moved to dismiss. The district court dismissed the appellant's case, citing a lack of subject matter jurisdiction. On appeal, the Fifth Circuit appellant claimed that the district court erred in concluding that the bar jurisdictions, blah, blah, blah. Okay, joining the Ninth, so it's joining the Ninth, 11th, and 3rd Circuit, so this is the 5th, so essentially it's dominating. The court affirms that the NIW expressly and specifically vests discretion in the Attorney General to deny national interest waivers, thus jurisdiction bar in section blah, blah, blah applies. So if you get these NIW denials, I guess in most places you can't, or there's a chunk of places, you can't appeal to federal court. There's always this way around it to say they didn't provide like a review of it. I'm not an expert on federal court filings, but I know a lot of people are suing on EB1As and L1s and stuff like that. Sometimes you find your way in there to do something, but just be mindful that NIWs may not get that appeal. You might need to refile it, maybe the better way to go. Number 4, I had a unique situation with a person who was here on a TN and was marrying a diplomat, and they wanted to say, okay, I'll like get diplomat status, and then they were like, how does work permit work? I'm like, oh, you just file an I-765 and that works. And when I was reviewing the I-765 EAD instructions, and I'm pulling it up now, I thought it was going to be a basic filing because he needed to get work authorization fast. So I said, okay, file the I-765 with USCIS, and then we'll do an expedite request and say whatever the need is. But when I was looking over the instructions, like, oh, I got to take that guidance back. That was incorrect. Let's see, Diplomat. So when you're going to do an EAD for these categories, eligible for dependent employees at diplomatic missions, international organizations, or NATO, let's see, dependent A1 or A2 foreign government officials. So essentially, the one I was doing, a C1 category, it says submit Form I-765 with Form I-566 interagency record of request, blah, 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 let's see. So you have to send those forms to the Department of State. Okay, through your diplomatic mission to the Department of State, DOS. DOS will forward all favorably endorsed applications directly to USCIS for adjudication. So you don't file the I-765 for these dependents of A1, A2, like, diplomat spouse, C1 EAD categories. You have to send them through your diplomatic mission to DOS, Department of State, and then DOS takes it from there. And then they, if they favorably endorse it, they give it to USCIS, which is a completely different process than I'm used to. But also when it comes to expediting it, then you have to, deal with the diplomatic mission getting things done in time, and the Department of State. I guess maybe do an expedite request to DOS through congressperson maybe, and then they move to USCIS. So I've never done it, and in this case didn't move forward. But if you're trying to expedite this kind of case, you have more issues than just calling USCIS or asking EMLA for an expedite. You got to deal with other agencies, which is always fun. So that's something to be mindful of. If you run into something like this, give good guidance. A couple of notes on the online Form I-130. One thing we're doing more is filing cases online. So the N400 and the I-130, we're doing the USCIS.gov online filing. If the client is able to kind of deal with the online kind of stuff. But there was some weird stuff popping up. There was a period of time they fixed it after a lot of complaints came through. Ayla, I think, saw a lot of postings, then reached out to USCIS and fixed it. But the G28 section of the form wasn't working. So when we went to like accept and say like send to G20, I'm the lawyer, the link wouldn't work for a couple of days till they fix that out. So be prepared for that kind of stuff happening. If it does, you got to contact them or maybe contact Ayla to contact USCIS on your behalf. But we have other things that are popping up, which is where like the address history question for the petition, the 5-year address history is just not coming up. So that was kind of weird. For current address, it doesn't allow you to write present, so you have to just put a date in randomly. And it's not always like this. Like the 5-year address history for the petitioner, sometimes it asks, sometimes it doesn't, but it's always got to ask. It's pretty standard on the form. So that's a weird thing that's popping up. Be prepared for. And I mean, sort of related with USCIS.gov is we are, at least I have a screen name associated with the old format where we could input a case number and get emails and text messages when there's updates on there. I don't think new people could do that anymore. My associate hasn't been able to log in to do it. So I don't think that's possible as much as it used to. But it was a really good system because randomly we get emails that say you got RFE, you got approval, we got your receipt or whatever, which is really cool. But in the last week or two, and we're recording this July 3rd, they haven't been updating the USCIS.gov updated system. So this is for anybody. If you check your case status online, that system, like we have cases where EADs were approved or RFEs were sent for medical, and there were no updates happening there. So until the client got the mail before we did and told us, we hadn't noticed it. So that was kind of annoying that that's the case. But hey, it is what it is. That's USCIS.gov for you. The number 6 thing I want to talk about, and I've talked about this in the past, but it's very important. I see people pro se doing this a lot, but I've had lawyers do this too, which is if someone gets their marriage based on it's their green card based on a marriage, not marriage based on green card, which is fraud. That's a Freudian slip, I guess, because it goes to what point it is here. If someone gets the green card based on marriage and then they get divorced and turn around within 5 years of getting that green card, they go and petition for a new spouse, that has a higher standard of proof required to make sure there's no marriage fraud happening there. And I've had this. I had one lawyer do this, and we withdrew the case and then refiled after 5 years. I had someone else who get the case denied for fraud, and it was a good case. It just shouldn't. They were 4.5 years into their their green card, and then they got remarried and filed, and then they denied it for fraud. And they came to me, and I was like, I can't help you because I didn't have time. But if they had come to me, I'd say, listen, you have 6 months left. Just wait those 6 months to close the 5-year period, then get married and file. Why not do that? So be mindful of this kind of stuff. The 5-year, and there's more to it. I think you become a citizen, maybe at OKSIP, you get citizenship 3 years, maybe. Can't remember all the details, but it's very important that you be mindful of this exceptional, this higher standard of clear and convincing evidence thing. It's in this INA as well. It's pretty high standard. I just didn't do my homework to cite any specific regulations, but just know if someone gets a green card based on marriage, gets divorced, files someone new, there's a timeline that they need to pass to not have a higher standard of scrutiny, which it's a much higher standard of scrutiny. So you don't want to mess around with that. It's better to wait unless you have really good evidence that the first marriage was real. Number 7 is something I learned embarrassingly. So there's automatic revalidation, which is typically the scenario I've always seen it, which I thought was the only rule was that we have people who are here who come into the United States on a student visa, an F1, for example. The visa expires, but they're still going to school. If they visit Mexico and come back within 30 days with a valid I-20, even though the visa expired, they get automatic revalidation. They can just come back in as long as they're in contiguous territory, maybe Canada as well, and it's not for 30 days. So I always knew that, and there's some exceptions for it. For example, someone who's from Iran can't do that because that's an issue right there. Or there's a couple of countries. Let's see what countries they were. So if you have Iranian citizenship, state-sponsored terrorism countries, so Iran, Syria, Sudan, you can't use it. And that's what I typically ran into. But I was talking with a colleague who said, oh, we do change of status. Someone comes in on like a B2, change of status to E2, and then goes visits Mexico and can keep coming back. I'm like, oh, wait, they're not student visa holders. How could they keep coming back if they don't have that status? So I went back and read the DOS site on there, and the CFR language is 8 CFR 2. I'm sorry, it's okay. Title 22, Chapter 1, Subchapter E, Part 41, so whatever that is, Section 41.112D, which goes into this automatic revalidation. But apparently, yeah, if you if you came in on a visa and then you have a new I-90, what is it called? I-94 that's valid, you could do visa validation with some exceptions, like again the state-sponsored terrorism issue. If in possession of an F1 student or J1 visa exchange visitor traveling to Cuba, in possession of an M1 has traveled outside location other than U.S. and Mexico, you went to non-contiguous or adjacent islands. So it's more than 30 days that you've been out. So it applies to more than just student visa holders. And, you probably already know, but it was news to me. But there's two more notes. One is you've applied for a new visa and was denied. It's like, okay, if you're already in the United States, I guess as if you left within 30 days, apply for a visa, was denied, you can't come back. You shouldn't mess around with that. But another is if you applied for a new visa which has not been issued. But does that mean if you file for a DS-160 but haven't like had an interview, is that considered filing for a new visa? So you're here in the US, you fill out the DS-160, you go automatic revalidation, come back in, and you didn't even do a visa interview. Does that mean you can still come back in, or is that a problem? Or how does that work? So I guess the idea they're trying to prevent people from using automatic validation, try to get a visa, and if the visa is denied, be able to just come back in as a backup plan B. That may be it. But I just share the information with you. There's more to it you got to learn about, but automatic validation is an interesting, piece of law that exists. It can be really helpful. There was a nuanced case. Someone came to me. It was very interesting. So they were here on some sort of status, and they left the U.S. And then came back in with automatic revalidation. So they had a new admission. And then we have to file an I-539 for them to change status from a F2, a spouse of student visa holder, to a spouse of H-1B because their spouse got it. And the I-539, it says, since your last admission, have you violated your status? And the great thing was we could honestly say no because they left and came back, had new admission. Whereas if they hadn't left, they would have had a violation because they violated in some way. But that automatic validation saved them. Now, I guess if CBP asked them about the violation, they would have prevented coming in, but they didn't ask. And there's no thing in here that talks about visa violation to come back in that I'm seeing. So it was an interesting thing to reset the clock to be able to do the I-539. And I think they had done the I-539 already, and they came to me in that issue of whether they had done misrepresentation because they had a violation, but they still filed an I-539 would have worked. And then they had the cutoff for that revalidation, so they had a new admission. The I-539, they pull up the form itself. It's very specific. It doesn't ask about all history. It just asks about recent history. And I think it's like 2 years ago. It's coming back to me. I think they were going to adjust status now, and there was going to be employment-based adjustment status. So under 245K, previous violations are okay on previous statuses, so it would have been okay. So it was this nuanced situation that worked out really well, and it taught me the power of automatic validation to reset the clock in admission for the I-539 purposes. So I just pulled up the form right now, and here in the violation sections, a lot of questions about different things here. Let's see. Let me just control F it because there's a lot of questions. Admission, okay, that doesn't come up. Violation, let's see if it comes up. Violation. Have you or any other person, including this application, done anything that violated the terms of non-immigrant status you now hold? Is that how it was asked? I think it was different at the time. That you now hold on your non-immigrant status that you now hold. Does that mean? I guess that's a new non-immigrant status because you get a new I-94 once you enter on automatic validation, right? I think it was worded differently here because I remember saying since last admission. They may have reworded it, but hey, just keep an eye out. This kind of stuff may pop up that can help you out. Okay, let's go to the next one, number 8. Ombudsman's office said you could sign. Okay, so I hadn't done an ombudsman's request for a while, and we're doing one, and it's easier for me to just do it for the client rather than give it to them. But I was under the impression that the client has to go and sign it. So I gave them instructions to fill out the form for the ombudsman's USCIS ombudsman's request, and they're doing it, and then it was still a hassle. But then reading it or something, I realized that for them, a lawyer could sign on their behalf and submit it. Double check that, but I didn't take exact notes on the source of it. But I was like, good to know. So you could do that. But Ombudsman's office was at the USCIS, at the AILA conference, and they're really nice people. They just issued their new annual report, which I started reading. I'm going to go over it and have a separate podcast on that. But they could be really helpful in a lot of different things. And I'm going to ask them to try to help us out or help clients out on certain matters. Like, for example, the form IA-24, this useless form that has delays. And the main reason I get clients based on this is because they fill out the I-130 incorrectly and they write adjustment of status instead of consular processing. And that causes them to need to do an IA-24 because the case gets stuck with USCIS, they'll transfer it. So I'm going to ask the Ombudsman's office to say, hey, USCIS, we'll just base whether they're going to adjustment or consular processing, base it on the current address of the beneficiary. So if they list that they're living overseas, the client shouldn't be able to need to specify whether they're doing consular processing or not because they're not competent enough to know what the difference of this stuff means. You should just assume it and always, essentially err on the side of consular processing. because if you adjust later, it's okay. But if you say adjustment and you want to do cost processing, that's not okay. That creates a lot of problems. Number 9, Department of State not adding me to cases. So I'm getting, NBC notice. NBC clients get NBC welcome email. I'm not added to the email address, so I contact US DOS NBC and say, hey, you didn't add me. They're like, oh, you are on the case. Because at the same time, I get notices and the welcome notices in the mail. So they're not adding my email address or emailing me, but they're sending me mail notifications about starting the case, which is annoying because I need to add my email now so I get notifications like when it's DQ and stuff like that, or if there's an RFE on it. But they're not adding me my email address to the case for these notifications, but they say I'm on the case and look, you got the letter in the mail. I'm not sure why they're playing these games, wasting their money on mailing stuff to me, and then this back and forth. I'm trying to get them to add my email address to the NBC case so that I get notifications. But be prepared for that. And I kind of forget because it consistently happens, but I got to tell clients that once the I-130 is approved, notify me once you get the NBC welcome notice, because by the time it comes to me in the mail, it takes much longer. And sometimes we'll just be waiting because I'm waiting for the NBC to email me to let me know to start the case, but I'm not getting the emails. And then I ask the client, like, oh, yeah, we got the email like 3 weeks ago. And I'm like, oh, we just wasted a couple weeks. So be mindful of the NBC's failure on this part for your cases, your I-130s and I-140s that are being transferred over there. You might not get notification. Your email might not be added, which just reminds me I got to contact some clients just to remind them about the same issue. And then number 10, this is an interesting case. The Board of Immigration Appeals concluded, I'm sorry, not the board, but this is some sort of case. So I'll read it. It's a false claim to citizenship case. Immigration granting, okay, so they granted a petition of review of a decision of the Board of Immigration Appeals and remanded. The panel concluded that Ramirez, the applicant's misrepresentations about his citizenship to police officers for the purpose of avoiding removal proceedings did not render him inadmissible and therefore ineligible for adjustment of status under 8 U.S.C. Section 1182, for falsely claiming U.S. citizenship for any purpose or benefit under law. The panel explained, and I think this is the Ninth Circuit. Let me double check. This is kind of amazing. Yes, Ninth Circuit, Ephraim Ramirez Munoz v. Merrick, Garland, Ninth Circuit, 2023. Let me bring back my notes. The panel explained that the BIA's interpretation was incoherent in that it bestowed under, quote unquote, under, with two different meanings at once, as if the statute read, quote, for any purpose of the alien related to any law or any benefit provided by any law. The panel also concluded that the BIA's interpretation was unreasonably broad, explaining that it encompassed lying about one's citizenship with the purpose of avoiding removal proceedings, regardless of whether the lie's recipient had a legal obligation to obtain citizenship information and report suspected undocumented persons to the immigration authorities. Rather, the statute would apply when an individual lies about his citizenship to anyone at all to minimize the risk of being detected by immigration authorities. The panel concluded that statutory text and legislative history show that Congress did not intend false claims to sweep so broadly. Rather, Congress' concern was with individuals who falsely claim citizenship to obtain a legal benefit reserved for citizens or to invoke a law intended for citizens, which, my words, is kind of problematic because what if you're going to get work authorization that is entitled to green card holders, not citizens? So I didn't fully read the whole case, but it was interesting they went into this. If a case like this pops up, sorry I didn't do full research. I didn't plan to do this podcast today, but I had these notes that I didn't fully right now. But I say, you know what, let's start getting this top 10 back in. But it's an important case. It's Ninth Circuit. Based on the synopsis I put here, I see some errors in the core. At least we're reserving this language about reserving stuff for citizens, which is incorrect. It kind of reminds me of the Supreme Court case that was decided, a very terrible decision decided last year, where the DMV for this one guy mistakenly registered him to vote, I think, and he didn't need to be a citizen to get the driver's license because he had an EAD, so he was entitled to it. So he wasn't trying to get a benefit of an act that he wasn't entitled to. So USCIS and like the Board of Immigration Appeals both denied him incorrectly, and the immigration judge denied him incorrectly. And then the Supreme Court said, you know what, even if they're incorrect, you're out of luck, which is a crazy decision. But how does that go with this and mistakes and stuff? It just makes it really messy. But important case to learn, and I'm going to have to read it again because it's kind of false claim stuff pops up, but it's on my reading to-do list. Ephraim Ramirez Munoz, Ninth Circuit. Interesting stuff. So that was the top 10 for this month. I hope you enjoyed it. Please email me if you have comments about the show or anything like that. I love talking with you guys. If you want to join the peer group session, the lawyers session for people, solo practitioners that want to grow their firm, We're happy to talk about stuff. Yeah, a lot of interesting things happening in immigration. Hope to take more notes and continue this series along with the other stuff, interviewing a bunch of immigration lawyers. Subscribe and get access to the podcast, wherever you're listening to this so you get the updates. I'm going to try to get back into the consistency of trying to do 2 podcasts a week. And thank you for everyone who met up in Orlando for the conference. It was good to see how many people are listening, reading the magazine, following us on LinkedIn. So much different activities happening, and really appreciate all your support. It really makes this job much better and much more pleasurable doing it. I guess that's it. Everyone have a happy Independence Day. God bless. Be safe. Bye bye.